Hello, everyone, and welcome to Immigration and Jobs Talk Show. I am Nipasa Pradhan. I'm very happy to have you with us today. Before we start off, I have this important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, dearest friends, this is Nipasa Pradhan on Immigration and Jobs Talk Show, and I'm very happy to have all of you join us. So, we are streaming live right now on YouTube, LinkedIn, and Facebook. So, to make this session a more interactive one, please feel free to comment your questions. And today's topic is a continuation of our previous episode with none other than our guest, Attorney Chand Parvathaneni. And in our previous episode on the same topic, is your H-1B at risk? We have already covered a few questions and we even took up your questions. Thank you so much for participating last time also. And I'm expecting the same this time. So, looking forward for a very great session. And without further ado, please help me welcome back Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. Chand, it's really great to have you back once again with us. Thank you for joining us.
Thank you, Nipasa. Hopefully, we'll have a very productive discussion talking about various wage issues that we typically see in H-1B. Some companies don't follow the rules, they violate the H-1B. And what we typically see is when the company is not following the rules, sometimes the employees bear the burnt of the employer's actions. The employer is not doing the right thing, the employer is not paying the employees on time. And then what we see is USAs come back and revoke their H-1Bs, or they go for stamping. They have problems at stamping. So what we want to do is we want to have a good uh, educative session where the employees know their rights, employers know their requirements too, because sometimes employers accidentally make some mistakes too. We have seen cases where the salary got increased during an extension or an amendment. Employer accidentally did not update their payroll, not their intention to not pay the employee, but sometimes it's an accident. And sometimes it's also intentional. Some employers bench their employees, which is completely illegal. So I think the goal is what are the things that employees must always consider, always look for while their H-1B employment is going on. Things that they are supposed to look for. Look at the LCA, look at what their requirements are. Make sure the employer is following the rules. And doing so, tomorrow, even if employer makes a mistake, they are not jeopardizing their career. And we'll discuss more as you have more questions for me. But I think it'll be a very good session where we educate people on what needs to be done to ensure both the employer is doing the right thing, the employee is doing the right thing, and following all the H-1B regulations.
Absolutely, Chand. I'm very excited, and I'm sure all the folks out there are also very excited about the same. So, I think without further ado, I will jump in right to the questions. And this next question that I have is regarding LCA, the Labor Condition Application Violations. So, what obligations does an employer have in accurately completing and posting the LCA for an H-1B employee, Chand?
Sure. So an LCA, the labor condition application. So this is a filing that an employer has to do with Department of Labor. And as a part of this filing, employer has to meet certain requirements. And the primary requirement is the LCA is public information. So the employer has to ensure that everybody has access to this LCA. So if anybody walks into their office, they should have access to the LCA. The employees of the employer, they need to know when an LCA has been filed. And the reason for that is, as a part of the H-1B program, the government does not want the H-1B program to be used to undercut the wages of the local people, the citizens, the green card holders, and so on. So the H-1B program should never cause anything to tamper with the labor market in US. And for that reason, the law is very clear. The employer has to follow certain things. And one of those things is actually putting that LCA up for public inspection. So that is very important. And the primary obligation that they have is accurate completion. So the LCA has information like job titles, duties, work location, wage offered, and other details about the employer. It is very important that the employer completes this information accurately. Any misrepresentation, any inaccuracy, employer can expect penalties. So it has to be completed accurately. And once it is completed, a notice has to be given to the public. And what that means is you do these things, you actually put a notice out there, maybe on the notice board, maybe on their website, where everybody should be able to see what is the LCA that this company is filing, what is the salary that is being given to the foreign worker who is going to be on H-1B. So there is this requirement that if people know what is the wage being given to the H-1B person, if public knows about it, that will ensure that the employer is not actually undercutting the wages. So that is why the LCA not only has to be accurately completed, but a notice is also required to be given to the public. And the way it works is a notice has to be posted either in the office of the employer, or an electronic notice to all the employees of the employee has to be provided. So this notice requirement is very important, and that accurate completion of the LCA, that is also very important. So if they're providing a certain salary to the employee, that has to be mentioned. So these things are very important, and accurate completion is super important. Once that is done, the LCA is filed. The next part is wage attestation. So as a part of this LCA, employers must attest to paying the prevailing wage or the actual wage, whichever is higher in general for a position. And this wage should be consistent with the wage determination. So there are certain rules on what kind of a wage can be given. The employer cannot randomly put some salary. So Department of Labor has certain requirements based on which the salary for a H-1B employee should be determined. So that wage has to be given. And as a part of the LCA filing, the employer has to disclose what is the wage determination process that was used. So it has to be disclosed as a part of that LCA. And then the posting requirement that we were talking about. The employer is required, it's mandatory to post the LCA in the workplace. And this posting must be done for at least 10 business days. So every employee in the company should typically have access to this posting. And what that means is, if the employees who are already working for the employer know the salary being given, they know that the employer is actually giving the right salary. So this posting requirement and wage attestation is super important. And then the record keeping. So once the LCA is filed, employers should maintain copies of the LCA and any related documentation for 1 year, even after the employment ends. So as long as the employee is employed and 1 year after the employment ends, there is something called public access file. So the public access file has to be maintained. And if any public person comes to the company and says, I want to inspect your public access file, the company cannot refuse. The company has to disclose the copy of the LCA using that public access file. And any public in US can go to a company and inspect the public access file. So the record keeping and public access files is a very important obligation of the employers. And then the final thing is compliance. So everything on the LCA must be complied. So there are terms: the duration of employment, the wages, the working conditions, the location of the work, and the title, the occupation. So employer has to comply with the entire terms. If there is any change, there is a work location change, there is a material change in salary, there is a material change in occupation, the duties. So anytime any of this happens, the company has to again file a new LCA, do an amendment filing, and follow the process. And failure to meet any of these requirements these are obligations, mandatory obligations. Failure to meet these obligations will result in penalties, including back pay, fines. And most importantly, if DOL comes back and says that they're not following the rules, they can even lose their future H-1B sponsorship options, which means they cannot even file for H-1Bs. Hello,
Thank you so much,
Nipasa.
Chand, for the detailed
Any?
explanation.
Yeah.
Yeah. I don't know, there's some lag issue, I guess, but I'm glad it's not that
Network
bad.
glitch. Yeah.
I'm so happy
Yeah.
that, we are joined by these amazing friends out there, Raghav, Dipti, and Arpita. Thank you so much for participating with your questions. And I'll just say, stay with us. We are very happy to have you all, and we'll take up your question in a short while in the show. So, Chand, my next question is also regarding LCA itself. So, how can employees identify and report discrepancies between their actual working conditions and the details listed in the LCA?
Sure. So again, this is a common question that I get a lot. The reason is just yesterday I had a paid consultation with one person, and he called us and said that he does not know what is in the LCA, and
Mhm.
apparently the employer just gave him a approval copy of the H-1B and said that is all he needs to get, and the petition documents in LCA are not mandatory; they don't have to be disclosed to him. So he does not even know what's in the LCA, and the government rule is very simple. The employers do not have a choice. If they file a H-1B, the LCA copy has to be disclosed, has to be given to the employee. So if there is
Mhm.
anybody out there that does not receive the copy of the LCA, send an email to the employer in writing demanding the copy of the LCA. It is not an optional requirement for the employers. The LCA has to be disclosed. So everybody should have a copy of their LCA because the companies have to disclose it. And it is super important that everybody review the LCA. They need to look at the LCA, and there is something called the work location in the LCA. There is salary in the LCA. There is occupation in the LCA. So once the employee gets a copy of the LCA, it's the employee's responsibility to look at the LCA and make sure everything is accurate. Are
Mhm.
they working in the right occupation? Are they working from the same location or in the same metro area? Are they being paid the right salary? And they should compare with their actual situation. If there is a discrepancy, they should talk to their employer because that is the first place employees will know if the employer is doing the right thing or not. Any discrepancy in the LCA and their work conditions, something is wrong. So always get a copy of the LCA, review the LCA, and then the next part is document any discrepancies. So take a look at your pay stubs, look at your LCA. Something is not matching, document it. Look at your job description, look at the occupation as listed on the LCA. If there is a discrepancy, document it. Maybe check back with the employer. So you're documenting the issue. Also check back. Also look at the number of hours you're working and see if the LCA states anything different. Is the LCA saying full-time employment? Is the LCA saying part-time employment? So just take a look at your
Mhm.
LCA and document any discrepancies. And if you're seeing anything in the LCA is not matching or not aligning with what was promised to you and what's in the LCA, document all the discrepancies. Then go back and
Okay.
communicate with the employer. So if any discrepancies are identified, just raise the issue with your employer or your HR department, seek clarification. Because if it is something that is an accidental mistake, a human error, the employer will quickly fix it. So maybe you're supposed to be paid $10,000 a month, and the employer paid you only 9,500 a month, for example, that particular month. Maybe it's
Mhm.
an accident, maybe it's intentional, but again, you have to communicate with your employer and see if it is something that they can rectify. Because many times, probably the employer just made an accidental human error and they will fix it. If they fix it, there is no issue. If they don't fix it, you're documenting the issue because tomorrow you'll need that evidence. Gather all evidences, any additional evidence such as witness statements, co-workers who are also experiencing the same situation. I had one case where we went back to the employer was actually giving the LCA copy, but particular employee said that the employer never gives the LCA copy to the employees. All the other
Mhm.
employees stated that they did get the copy of the LCA. So sometimes we don't know who is lying. So what that means is get witness statements from your coworkers. Okay, because if multiple people are facing the same issue, more than likely
Mhm.
it's a genuine issue that multiple people are facing. So always gather witness statements, especially from coworkers or whoever are in a similar situation. And once you have all of this stuff and the employer is still violating some regulations, at that
Mhm.
particular point of time, I mean, again, what I would advise is like try to resolve it with the employer. Don't go and jump and file a complaint even without trying to resolve the matter. Try to resolve the matter. Okay, because the company is probably doing the right thing, and maybe something happened. So always check
Mhm.
back, document, and get some clarification from the employer. I would not say jump and file a complaint with DOL even without doing all these things. I don't want you to waste DOL's time until you had a chance to figure out what is happening and try to give a chance to the employer to correct the problem. If everything fails, at that point of time, I think is when your resort should be DOL. At that point of time,
Mhm.
there is Department of Labor's Wage and Hour Division. It's called WHD, Wage and Hour Division. You can go to their
Mhm.
website. Their website has a complaint form, so you can always make an online complaint and explain what your issue is. Are you not getting the wages you're supposed to be paid? What
Mhm.
happened? Or is the employer forcing you to work from a location that is not listed in the LCA? So
Mhm.
whatever is the issue, you will be able to file a formal complaint on the DOL website, on the Wage and Hour Division's website. Uh, Alternatively, you can even call the DOL's regional office to report a violation. But the website is a pretty simple place to get the complaint started, and give as
Mhm.
much information as possible in the complaint form. DOL is going to be confidential, and the employer cannot retaliate against you because you complained. There are whistleblower protections offered by the government. So always be as thorough as possible in the complaint, because you don't want to waste DOL's time, but you want to give them a chance to investigate properly. So do give them the information. Don't file a normal complaint without giving them the information. Give them proper information and then file a complaint. And DOL typically will assist you. Normally, what we see is
Mhm.
DOL will come back, they'll go to the employer, find out what is happening. And if it's really an accidental mistake where the employer really made an accidental mistake, it's not uh, a recurring issue with that employer, they will sometimes will make them fix the problem. And depending on the severity of the problem, sometimes they will even issue a penalty to the company. They can penalize the company. Sometimes they might even uh, debar them from the H-1B program. And if the company gets debarred from the H-1B program, the company cannot even file H-1Bs. So DOL is pretty powerful. They are pretty helpful in resolving wage issues, and employees can be assured that the complaints to the DOL, they are confidential, and retaliations for reporting issues is typically prohibited by law. So it is going to be confidential. And again, if your issue is really bad, you can always seek assistance, legal assistance from an attorney, maybe an
Mhm.
immigration attorney, maybe a labor law attorney, depending on what your issue is. And doing so, you can not only effectively identify the problem, work with your employer to resolve the problem, or take DOL's help to resolve your wage issues.
Okay, Chand, thank you so much for taking that up and for explaining it to us so thoroughly. It's very nice to have you do this for us. And meanwhile, we have RK, we have Rekha, and thank you so much for joining in. We are going to take up your questions. You just have to stay with us. So, Chand, I think I'll take another one, and this is what enforcement mechanisms are in place to hold employers accountable for LCA violations, and how can an employee file a complaint?
Sure. So right now there are several enforcement mechanisms in place, and these mechanisms will help hold an employer accountable for violations of various H-1B regulations, or specifically in this context, LCA violations. And it is very simple to get the process started. So there are good enforcement mechanisms. And I think the first and primary concern that I get is employer has made a mistake. I'm getting jeopardized. I mean, my career is getting jeopardized because of this reason. Tomorrow I'll be penalized. I can't even transfer because I don't have the pay stubs. So these kind of issues keep popping up all the time, and we'll discuss more on how to handle those scenarios. But in terms of the mechanisms available, first and foremost, the DOL investigation. So normally we know that a legal action is very expensive. You hire a lawyer, you go to the court. Yes, you can do it. It's expensive. So for all practical purposes, the government try to make it as simple as possible, and they've basically given DOL, the investigation authority. So DOL investigation, it is easiest to get started, and DOL has the authority to investigate complaints regarding LCA violations. So all that means is you go to DOL, you complain what has happened. You basically, if you have an LCA violation, tell them you're not getting paid or what exactly is happening. And any LCA violation, what in my experience, what I've seen is DOL very diligently conducts investigations on LCA violations. They will conduct an audit, they will inspect, and they will ensure compliance. So DOL investigation, for all practical purposes, is pretty quick, and it does not cost you any money at all. So that is one of the best mechanisms available out there for enforcement. The other one is the court system. So you can always go to the court system, go through the court system, bring a legal action, and file a lawsuit against the employer. You can always do that. That is expensive, but again, that is also a very good mechanism because the court system is pretty powerful in US. There is due process. Everybody gets due process. Everybody gets to give their response, file their response in the court. And but again, if somebody has done something wrong, the legal action will definitely help, uh, especially for breach of contract, for wage theft, and so on. And then there are also civil penalties. So, because the government does not want an employer to just come back and say, "Hey, I made an accidental mistake," and get away. There is something called civil penalties. So employers who are found in violation of LCA requirements, they may even face civil monetary penalties. And depending on the severity of the violation, the nature of the violation, sometimes these penalties are extremely, extremely high. So civil penalties is a good mechanism, enforcement mechanism that the government uses to ensure that people don't violate the LCA. And then we also have the back wage payments. So employers will be required to pay back wages to any impacted H-1B employees if DOL comes back and determines that they have been underpaid, or they have been failed to meet the requirements. To give an example, say it's a very, very senior level position. An employer files an LCA with wage level 1, for example. An employer complies with the LCA, the terms of the LCA. But if tomorrow DOL determines that they have been underpaid because the wrong wage level was selected, instead of paying wage level 4 for a very senior level position, they have paid wage level 1 by filing an incorrect LCA with wage level 1, for example. DOL will come back and make the company pay the back wages. Okay, so DOL has very good mechanisms, and companies having to pay the back wages, civil penalties, and one very, very good mechanism that they have is disqualification from future sponsorship. So if employers get to that situation, DOL will debar them from the H-1B program, and they cannot file any future H-1Bs. So if any employee is already working for them on H-1B, they cannot get extensions. The company cannot get future H-1Bs. And what that means is the company pretty much is out of the H-1B program. And a lot of H-1B dependent companies, they don't want that. They don't want to be debarred from the H-1B program. So this is a very good mechanism that the government uses, disqualification from future H-1Bs if they violate LCAs. So that is a very, very good mechanism that prevents employers from making any intentional LCA violations. Okay, so these are the things. And in terms of how do you make a complaint, gather the documentation, gather your evidence, contact the DOL, and you can file a complaint online. Phone complaint can be done, but the way I see it is an online complaint is more convenient because you have everything documented. And sometimes, if you want, you can even submit a written complaint and be assured about confidentiality. And if your situation is like really, really bad, always consult with an attorney and somebody that knows about labor rights, somebody that knows about immigration, and get proper guidance. And using these enforcement mechanisms and complaint procedures, what the way it helps is uh, not, very few employers are bad. So by these mechanisms, employees can hold employers accountable for LCA violations, and doing so, employers and employees, the good employers and the good employees, all of them will have this H-1B program. So in general, we don't want some bad apples to spoil this H-1B program. So uh, people should be aware that there are good mechanisms out there, and by holding the employers accountable, the system as a whole will function smoothly.
So true, so true. Thank you so much, Chand, for taking that up and for the detailed explanation. It was a great explanation. Well, I think without further ado, we should take up some questions from our chats. You know, our audience are waiting out there, and I see a couple of questions from RK, and it seems very urgent. So let's take his one first. Um, He's saying the enforcement is wrong, punishing the employee when employer breaks the rule when by benching employee, because the employee gets the back pay but loses their status and has to leave the US. If the option is to either report the employer or leave the USA, workers are going to rather stay and take less pay than to leave. There is no incentives the workers for the workers. It's silly the visa shouldn't be allowed to be granted at the embassy or CBP without the worker submitting a copy of the LCA with their passport. What do you have to say, Chand?
I mean, I totally agree. I mean, I kind of see the problem because I mean, I was involved in a lot of cases where there is this bad employer, and then because what this bad employer has done, now the employee's career has been jeopardized. I mean, we have seen this with multiple registrations where a company did a multiple registration, and now the employee was not able to transfer because even though the employee has not done anything wrong, because of the
Mhm.
employer's issue, the employee was not able to transfer. Employees H-1B has been revoked, and same thing with pay stubs. Sometimes we come back and see the employer not paying the employee. Now, in the current rules, what happens is USCIs, when they do a transfer, they come back and ask for pay statements. Even though it is not the employee's fault, what we see is USCIs will say, no, you have to step out of the country because you cannot apply for extension of status because you don't have the pay stubs. You have to go to the consulate, do the consular processing. So I definitely saw these issues where employer made a mistake and employees are getting the other end of the stick. I've even seen lawsuits. I
Yes.
mean, I've seen lawsuits from my colleagues, and I mean, you probably saw the lawsuit from Jonathan Wasden, who also comes and talks on this talk show. So,
Yes.
so they have raised these issues where the issues where employees are unfortunately getting penalized for the mistakes of some bad employers. So that's an ongoing issue, and hopefully we hope that USCIS will fix the problem in the future. But again, from your documentation perspective, I think at least the complaint. I mean, tomorrow USCIS cannot come and say that you have been a part of that issue. At least they know that you are a
Mhm.
victim. Unfortunately, the current rules, uh, I mean, I would say are a little skewed. Even when the employer is making a mistake, employees are seeing issues occur to them. But again, at least in the current fashion, the rights are that at least make a formal complaint, document everything. So when you go for a visa stamping down the line with a good employer, at least you have documentation to prove what has happened, and at least the consulate will not penalize you. I think USCIS, what they say is you go out of the country, get consular processing, and then come back. That is what they
Mhm.
say when you're not able to prove uh, that you're maintaining status by showing the pay statements. USCIS will expect you to go out of the country, do consular processing, get a visa, and come back. Unfortunately, I do see that employees are getting the additional burden even though they have not done anything wrong. But at least what you can do is document the issue and this complaint. What it will help you is it'll at least help prove that you have not been a part of the problem and you're just a victim in this process by this bad employer. And unfortunately, not all employers are bad, and there are few
Yes.
bad employers which cause a problem to the employees as well as the H-1B program in general.
Yes, that's so true. And RK, I know this is really unfortunate a situation, but let's see how can we come out of this, Chand. And yes, in case you have questions and you want to have a one on one consultation with Chand, why not maybe give him a call or send him an email? You can call him on his number 817-523-8247. And you can even email him regarding your case. And his email address is law@spblawfirm.com. And definitely go www.spblawfirm.com to get to know more about attorney Chand Parvathaneni. And Chand, we have some more questions, but I think let's take up this one from YouTube. This is from Raghav. My spouse on grace period had filed I-539 H-1B to B2 and is rejected. Now I have a job offer and we plan to file H-1B non-profit. If my H-1B gets denied, can we still file fresh I-539 to B2 after that?
Um, so, um, so when you're on the grace period, you have 60-day grace period on H-1B, and if the 60-day grace period has expired and the B2 the change of status to B2 is also denied, because I think based on this message, I get that I probably think that the B2 application has been denied. So now, if there is a job offer for H1B, so I think it's your spouse who got a denial, not you. So if you have not received a denial, you can definitely file a H1B, and because it is non-profit, you should not have an issue. So if the H1B gets approved, you should be good. But if your H1B gets denied, normally if your B2 is also denied, you have to leave the country. But if your B2 is not denied and your H1B gets denied, you can still stay back in the country till the day your B2 is approved. But your spouse, I think she already got a B2 denial, so she might have to leave the country. And once you get an approval, she might have to get H4 stamping. Okay, but again, if your B2 is not denied yet, it is still pending, or it is approved, you are good to stay back in the country, and then your H1B will be approved. But normally, if the B2 is denied, what happens is USCIS will approve your H1B in consular processing. You'll have to step out of the country, get stamping, and come back. So the bottom line is, if your B2 is not denied, you can stay back in the country, continue on H1 once it is approved. But if your B2 is denied, your H1B can still be approved. You just have to go out of the country, get stamping, and then re-enter the country.
Yes. There you go, Raghav. You have your question answered. And thank you so much, Chance, for taking that up for Raghav. And folks out there, if you have any questions, keep commenting. We are going to take them up. And meanwhile, Chand, I had a few more questions from our Facebook groups and also our YouTube comments. So I think we should address them. And yes, let's take up this first one. This is from an anonymous participant asking, hello, guys. Me and my fiance got engaged this summer, and I want to file for a fiance visa, but I don't know if it is better to file it with an immigration lawyer or on my own. If anyone has done this before or knows about this visa, please give me some advice and guidance on what to do. So, also, please let me know how was your experience with this type of visa. Thank you. Anything you want to say on this,
Sure,
Chan?
sure. Um, so when you say a fiance visa, the person should be a U.S. citizen. So I'm guessing he's a U.S. citizen, and then he got engaged to a foreign national, and they want to get married. So the fiance visa, which is the K1 visa, it is a pretty simple and a straightforward visa, and they should be able to do it. And again, if they want to use the K1 visa, the rule is that the visa gets issued as a non-immigrant visa. It's not an immigrant visa. It gets issued as a non-immigrant visa,
Hmm.
and his fiance can come into the country, and within 90 days they're supposed to get married, and then file for their green card. So the intent of the K1 visa is for the fiance to come to you. Uh, the purpose of the fiance visa is for the fiance to come to US, and for them to get married within 90 days and then pursue the green card. So if they're doing it, definitely K1 is a good option, and a lot of people use it, and it's a pretty easy visa. I mean, I don't think it's a pretty complex process, and even the burden is not very high, because when you say marriage based green card, the burden is a lot high because you have to prove a lot of things. A fiance visa, they just got engaged, so they probably don't have a lot of life together, so there is not much evidence to show commingling of assets and other things that you normally show during a marriage green card process yet. So the burden is not very
Hmm.
high. Main things are, he has to be a citizen, they have to prove that they have met, they got engaged, and file for a non-immigrant visa. It's a pretty easy visa, and I think they should be able to do it.
Great. Thank you so much, Chance, for taking that up. And I think I will move on to my next one. And this is from Shekhar Muddam. Hi, all. I have a question about H-1B transfer. I'm currently employed with a consultancy working as a contractor. My client company is willing to transfer H-1B, but I do not have a payroll on my H-1B, where my employer says issue with LCA to run the payroll, picked and approved this year. Number one, first question is, do I need a payroll to complete the process for H-1B transfer? And the second question is, will my employer be informed by USCIS after completion of my transfer? Looking forward for your help. Thanks and regards.
Yeah, sure. So this is a kind of a common question that I see a lot of times where the employer gets an approval and they don't pay the employee. So like again, this is one classic question where the employee has not done anything wrong. He's got an approval, the company is not paying him, and now he's worried whether he can even transfer. So I think like the other question we just saw a minute back, employee rights are, I think, kind of in a jeopardy because even if he wants to do a transfer, even if he has a better offer, because the employer has not paid him, now he's in a dilemma. And again, the answer for that is the new company can still file for a transfer. And if they don't have pay stubs, normally what happens is USCIS could ask them to process it in consular processing. He might have to step out of the country, get a visa, and come back. So the consular processing approval is still possible even without the approvals. And that is probably how he would have to deal with this transfer, because transfer is still possible. It's just that he might have to leave the country, get visa, stamping, and come back. Just because he does not have the pay statements, just because the employer has not paid him, and he's not able to prove to USCIS that he's maintaining valid H-1B status. So, so there is a little bit of problem, but it can be done, and that is why I think people should be aware of the LCA, and they should keep a copy of it because it is mandatory that they have to be provided that copy, and know their rights, because you have to know your rights, because if somebody is violating the law, that is the only way you know what is going on. And
Yes.
regarding the last question, will my employer know about the transfer? So USCIS is not going to go back and tell the previous employer that this employee is transferring to another employer. The USCIS will not go back and say that. So once the transfer is over, employee is free to switch. So because I also get that question a lot. If I initiate my transfer, will my previous employer know about it and fire me? No, typically it does not happen that way. The old employer will not know because you got a new offer and some new employer filed a transfer for you. So people should be able to transfer freely without being worried about their previous employer knowing about the transfer in process.
Okay, that's great. Thank you so much for taking that up for Shaker. And moving on, Chand, I have more questions to take. I think the next one we should take up is from our YouTube. You know, we have comments and folks out there have a few questions, and only attorneys can answer that. So
Mhm,
this
sure.
one is from Pradeep Portal, uh, asking, is Indian chartered accountants considered for H-1B specialty accusation for accountant job? I have only Indian chartered accountant certificate.
So
That's all. Yeah.
yeah. Yeah, sure. Again, this is also a very good question because every year I see some people with chartered accountant certificate in India apply for H-1B. So the rule for H-1B is that the occupation should be a specialty occupation, and specialty occupation means you need to have a bachelor's degree or more in in a specific occupation. And what that means is for for accountant position, for example, a, a bachelor's degree in accountancy, that's a valid degree, so it is a specialized occupation. But in
Mhm.
India, chartered accountancy, it's not really a degree, it's kind of a license. So just based on the chartered accountancy, somebody will not get a H-1B. A license is not enough, it is the degree. So what people do is they also have to do an evaluation of their educational qualifications, sometimes maybe even use their work experience qualifications, and find
Mhm.
what is their equivalent degree in US. And if their equivalent degree in US is in the right field, in this case accountancy or finance, they should be eligible to do a H-1B. So my thing is, you can't use the chartered accountant license. But again, if you got that chartered accountant license, it means that you're probably very experienced. You have the right education. So you do a equivalency of your education and work experience, and if that equates to a degree in this relevant field, which is accountancy, then you should be eligible for H-1B.
All right. Thank you for taking that up, Chand, and for the explanation for Pradeep. Pradeep, I hope you got your answer, and thank you. Thank you. Let's move on to this next one. This is from Muhammad Wise. Hi, ma'am. After 221G refusal, I submitted my documents and my case is approved. But I have not received any further email to submit my passport. Can you please tell me how much time it would take? Because it's already gone 1 week. So it's been a while, maybe a month or
Sure.
so.
Yeah. Yeah, and I think this is a good question for a lot of folks out there. A 221G. So once you get a 221G, what happens? So once you get a 221G, I see anywhere between 2 weeks to a couple of months to get an approval, and it does not happen quickly. It does take some time, and depending on the kind of 221G, what happens is sometimes the consulate asks for some documents. If they're asking you for some documents, submit it immediately, and immediately as in like at least a week or 2 weeks. Don't take too long. And sometimes you get a 221G where they're not asking for any documents. What that means is they're going to do some background checks. And more than likely, what that means is your employer back in US, they might get an email with some verification requests. Tell the employer to immediately answer once they get an email from Department of State. For almost nowadays, for almost all 221Gs, we are seeing emails being sent by the consulate, Department of State, to the employer and sometimes even to the clients where they're asking the clients or the petitioners, the H-1B employers, to validate some information, provide them some information back. So the sooner your employer provides those answers, your visa will be issued. So the consulate more than likely will not be reaching out to you, but they are more than likely reaching out to your employer. So check back with your employer, and the sooner they answer, the faster your background checks will be done. And depending on the kind of background checks they want to do for your case, I would say anywhere between 1 2 weeks to a couple of months. Generally, anything more than 60 days, you can always go back to the consulate and start inquiring about it. And typically, once you get a 221G, if you inquire less than 60 days, they typically do not entertain those requests. They expect you to wait at least 60 days before you go back and check on statuses. So that provides them enough time. So, so the bottom line is, if it's just a week or so, it is too early. They're probably processing the security checks on the back end and getting things cleared out.
Probably. But thank you so much, Chand, for the detailed explanation and the answer. Now let's move on to another question, and this is also on our YouTube. This one is saying, "Hello, team. I'm pleased to inform that I have been selected in the H-1B visa lottery and my petition has been approved. However, the company has expressed reluctance to share the petition documents with me for the next steps. Is there a way for me to obtain the petition documents directly from USCIS or through another method?"
Yeah, and again, this is also another common thing that I see a lot. Companies not wanting to share the documents. In general, the LCA is the mandatory document, so the LCA has to be shared. So there is no, I mean, the LCA has to be given, so the company does not even have a choice of not sharing that document. Apart from that, other supporting documents, a lot of times the companies, I can see them having a problem because it is the company's petition. Sometimes they don't disclose that uh, for whatever reasons. And from my perspective, what can you do? So what can be done is you can always file a Freedom of Information Act (FOIA). You can file a FOIA request
Mhm.
with USCIS, and by filing a FOIA request with USCIS, they will eventually give that information back to you. And normally, a month to two is what it could take. And what I would suggest you to do is reach out to USCIS, file a FOIA request, and try to obtain your documents. So, FOIA request is the easiest way to get at least a copy of your approval and pertinent documents on your file.
Okay. Thank you, Chand. Thank you for taking that up. And let's move on to another question. And this one is saying, "I want to know about the public law, the 114, 113 fees, which is another 4K dollars. Would this be added to all cases for new filing from 2025?"
So this fee has been there for a very long time. It's not a new fee at all, and this fee does not impact every employer. So if it's somebody like Microsoft, they don't have to pay these fees. If there's a company with less
Okay.
than 25 employees, they don't pay these fees. So the criteria is if a company has more than 50 employees in general, and more than
Mhm.
50% of the employees are on H-1B status, then the company has to pay the $4,000 public law fee. So if somebody like Microsoft, they have more than 50 employees, but they don't have more than 50% of their staff on H-1B, so they don't have to pay that fees. And if it's a small company with less than say 50 employees, they're not even having to have this have to pay this fee. So this public law fee is for that very narrow specific set of companies who have more than 50 employees, but at the same time they also have more than 50% of the staff on H-1B. So only those companies are required to pay this $4,000 fee. Other companies don't have to pay that fee at all.
Okay. Thank you for the update, Chand, and thank you for taking that up. And Tamil, thank you so much for. I hope you got your answer. Now we have this next question. This is from Divya. Good day. I have a query about the I-797B approved copy from the employer. I am supposed to book an employment at the consulate in Austria for stamping. However, I'm not interested in joining the company for an H-1B processed employer. And I would like to keep this form, change to a new employer, employer B, and then fill out the DS-160 visa. Anything you have to
So
say,
I
Karthik?
think yeah. I think she has an approval from one company, and I think her question is, can she put another company's name and work for that company because she got an H-1B
Yes.
approval? So the way it works is she can only work for the company for which she's authorized, and only in that role. So if she wants to work for company B, the company B has to file a H-1B for her, and then she can fill the DS-160 with that company's information. So what the company B has to do is the company B has to show her prior approval, the company A's approval, and file for a transfer. So the company B can file for a transfer, and if that transfer is approved, at that point of time, this employee can fill a DS-160 with company B's data. So the bottom line is company B has to file a petition, H-1B petition, get an approval. They can always do a transfer because company A's petition got approved, and then employee can start working for company B.
Okay. Thank you so much for taking that up, Chand, for Divya. And let's go on to back to Facebook for a couple more questions, if that's okay with you, Chand.
Sure, sure. Yeah.
So this is from an anonymous member asking, "Hi all. I worked for a Desi consultancy for 3 months and have 3 months worth of payslips. Recently, I received a full-time job offer and my visa transfer has been approved. I'm set to join the new company next week. I informed my consultancy about my new opportunity, but they have threatened me, accusing me of cheating and stating that they will not provide an experience letter. Will this create any issues for me in future if I don't have the experience letter? I do have the pay slips, but not the experience letter. Also, I was worried that they won't provide the W-2 form as well. Any workaround for it? Chand.
Yeah, and again, I think I see this a lot. I mean, I've been involved in some lawsuits where this was an issue, where somebody left employment and we had to file lawsuits on the same issue. So, in terms of the rules, the employee's rights. If the employee wants to transfer to a new company, the law says that nobody can stop them. So, somebody they have an H-1B working for somebody on H-1B, they want to change to a new employer. Employee can change to a new employer. However, everybody has to look at their employment contract and the legality and the legal enforceability of their employment contract, because everybody probably signed an offer letter or an employment agreement with the company, and they also have to see what clauses are enforceable. So if they violate that contract, the company, the employer, can go and file a legal action against them and claim damages. Okay, so it all depends on what your legal contract says and is it even enforceable. So depending on their clauses, their enforceability, whole other things, uh, will tell you whether the employer even has can do anything or not. And from a legal perspective, from an immigration standpoint, you can file for a transfer. So even if you breach your employment agreement, you can still go ahead and file your transfer. But if you breach your employment agreement, the employment agreement will specify what kind of damages you'll have to pay the company. So the max you'll be liable is the damages as per the employment agreement, assuming they're enforceable. So because employment agreements are enforceable, okay, depending on what clauses they have. uh, when maybe if the whole employment agreement is not enforceable, maybe a part of it is enforceable, which is why if you if at all you sign an employment agreement, always get your employment agreement checked by an attorney. So that being said, the company cannot stop your transfer. I mean, immigration will not say anything even if you breach your employment contract and go join another employer. But if the employer does not give you the form W-2, they stop your payments. DO, you have rights that you can enforce. So you can go to DOL, you can complain. You can go to USCIS, you can complain. So a company cannot withhold your wages because you joined another employer. So I mean, maybe max they can do is maybe they will not give you an experience letter, which is a possibility, but they will not be able to stop your paycheck. They will not be able to stop your W-2 because that is illegal, and you have a recourse. If they do that, you go to DOL or you go to USCIS. So paycheck is not something that you have to worry that they will stop it, because DOL will not permit them to do that. So you have rights. So if it is the paychecks you're worried about, the W-2s you're worried about, I don't think you'll have a problem. Experience letter, more than likely you might have a problem. But again, if the company does not give an experience letter, if it is for immigration, USCIS will routinely let you use affidavits. You can use your coworker affidavits if the company refuses to give you an experience letter. So that probably will not be a problem at all.
Okay, that is great news then. Thank you so much, Chand, for taking that up. And I think we should move on to our next one. Let's take this one. How long you guys waited to get the biometrics appointment? My PD is September 27th.
So
Zarwar.
I think yeah, so this is probably a question from somebody who has applied for I-485, the green card application.
Mhm.
And once somebody files a green card application, when their priority date is current, they get a biometrics appointment. And normally, once the 485 is filed, typically the timeline that we see is about a month to 2 months from the day their I-485 is filed. So typically, they should get it very quickly, 1 to 2 months from the time their 485 is filed. So, and this is primarily for the folks who have applied for adjustment of status I-485 application.
Mhm. Okay, Chan, thank you. Thank you for taking that up for Zarowal. And I think we should definitely move on to our next one. And let's take back to our, YouTube chats since we have not been taking all of them. So let's take up this one from Dipti. Hi, in case if I get promoted to IT manager, what would be the consequences given that I have approved the I-140 and green card in progress right now? I am principal software engineer. Please advise.
Sure. So, from the green card perspective, if one has an approved I-140, so whenever you have a promotion and it's a regular career promotion, it's a part of the career, and the job duties are still in the same line. Typically, nothing needs to be done. And if the job duties are not in the similar line, and it is more than a routine career progression, companies what they should do is they typically will file another I-140, and so ensure that the I-140 is accurate. So again, it is something where the company's attorney should look at your duties that were a part of the I-140 and your current duties, and see if it is like a normal career progression, or if they feel that it is a material change into a whole different occupation, completely different occupation or not.
Okay.
And the way to do it is not just look at the titles, but look at the actual core duties and your career in the firm. And doing so, they will be able to tell you. But again, worst case, your priority date is still going to be the old priority date. So more than likely, it is not an issue. But depending on what kind of a career progression you have seen, you sometimes companies will do an I-140, a new I-140, and retain the old priority date, so that way you don't lose the old priority date. And sometimes they say it's probably not required because it is in the same or similar line of occupation, and it's just a
Yes.
routine career progression. So that analysis is, however, is very important. So anytime I see a promotion, I always like to do like an evaluation of your I-140 job duties, your current job duties, just to be on the safe side. But more than likely, you'll
Mhm.
not have an issue.
Okay. That's very interesting, Chan. Thank you so much for taking that up for Dipti. And as we are approaching towards the ends, I have some more questions. I think we should move back to some of ours, Chan. So, what remedies are available, to employees if they were forced to pay H-1B filing fees for, or legal costs in violation of federal law?
Sure. Uh, we've been hearing a lot of recent issues where employers are asking employees to pay the fees. And not only that, I've recently seen two notice of intent to revoke where USCIS actually had proof. They basically said somebody went to the consulate and the consulate inquired, and these employees have actually paid the employer. And the consulate, what they do is they make somebody write these kind of statements in writing if that is what the employee is stating. So there is evidence. They are also gathering evidence. So I mean, whenever you have a site visit, whenever you have a consulate appointment, routinely this question comes up. The officers will ask the employee if they have paid any H-1B fees, any filing fees, etc. It is against the law to make the employees pay for H-1B filing fees. It is against the law. And companies typically will run into an issue if they get caught. So what that means is, again, from an employee perspective, you can go back to DOL and file a complaint with DOL. You can file a complaint with USCIS, and or when you go to the consulate, you can file a complaint with the consulate. The company will be red flagged. So company will run into issues if they charge employees for the H-1B filing fees. And USCIS, I mean, again, USCIS will not issue the H-1B visa if the company has got H-1B approval by making the employee pay for the fees. So it is very important because sometimes it's a very critical employee, but if the employer has made them pay some part of the fees and
Mhm.
they're caught, the H-1B is jeopardized. The H-1B is going to be revoked. So people have to be
Yes.
cautious when I say people, both employees and employers, because paying is also not a legal thing. Again, be cautious. I mean, again, if an employer is asking you to pay for H-1B filing fees,
Yes.
something is wrong because companies should not be taking money from the employee for filing.
Yeah.
And your remedy is go back to DOL, go back to USCIS, and finally, you can always bring an action in the court system. So you can always claim damages by initiating a legal suit. But again, that's a little bit more cumbersome process, and DOL and USCIS, that's probably the fastest way to get the complaint started. But again, to claim your damages, you probably will have to file a lawsuit and go through it.
Yes, thank you. Thank you, Chand. I was just going to ask if it's really legal or not legal, but you already gave the answer to that. So thank you, Chand, for taking that up. And this gives me, opportunity for this last question. And this is, if you could tell us, how can employees recover fees? Fees they were improperly required to pay in connection with their H-1B visa process. What would their next steps have to
Yeah,
be?
yeah, and I think what I always say is the first route, it should not be immediately jump up and file a complaint and waste everybody's time. I think the first thing should be reach out to the employer and try to see why they have charged you and try to see if they can just resolve the matter by paying that money back, because it's illegal. They should not be charging and employees should not be paying. But if that has happened, the first thing they should do is try to work it out and make sure the employer pays the money back. So that way it is clear and nobody is in trouble. And if the employer still insists that they're not going to pay back and they cause a problem, document everything and then gather evidence and then file a complaint with DOL, because DOL will typically get involved and will help in these wage matters. And because if somebody's wage is going below the LCA salary, because now they have paid this H-1B fees, whatever that amount it is, because now when you subtract that amount, they're falling below the LCA wages. So that is a violation of LCA, because now the employee had to pay back in those as filing fees. So their actual wage is actually less than what they're supposed to be paid. So it's an LCA violation. So DOL will definitely want to get involved and assist in the matter. So DOL will probably work it out with the employer, make them pay, sometimes even uh, 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 penalize the employer by civil penalties, maybe sometimes debar them from the H-1B program, seeing
Mhm.
how common they have been doing this kind of a violation and so on. So the bottom line is, work it out with the employer, try to get that payment back, because that is not something that they should have even taken in the first place. But if that fails, the initial negotiations fail, the employer is not willing to correct the problem. At that point of time, use DOL as the best recourse to get some help in such matters.
Absolutely. Thank you so much, Chand. And, we have been, like you had said earlier, so many cases lately have come up like this where the employees have to pay. So I think you must be also. Do you have any case study or anything that you want to share before we wrap up our show for today?
Sure, sure. I mean, again, this kind of like employees charging, I think we are seeing it more and more nowadays. So I think
Yes.
we just have an RFE that is due like in a day, where somebody said that USCIS, sorry, the consulate. So this employee came for the interview, and he said that he paid approximately a lot of money. I mean, a couple of thousands of dollars, which he should not even have paid. So the employee has given in writing. So now it is documented. So I definitely think that employer will have a problem unless they're able to counter and say what exactly happened. Because sometimes I've seen cases where I had one case where employee got a phone call, and employee apparently was confused and said something, and they issued a notice of intent to revoke for that H-1B. And then the employee clearly explained what happened, how he got woken up in the middle of his sleep and he didn't know what he was being asked. So it was a misinterpretation. So the employee clearly gave an explanation. So USCIS
Mhm.
was convinced. They reaffirmed that H-1B. But again, I think in reality, because I had some people call us and say that this is what the employers are doing, and they're having to pay. So definitely, I do think that there is this issue. I don't think it's on a large scale, but at least it is out there. So people should know the rules, which is do not pay. And if somebody is looking for a H-1B filing, and if an employer says pay us, I mean, don't work with that employer, because that employer is doing something wrong. And tomorrow you don't want your H-1B to be revoked after a couple of months for some violation, and then your career be jeopardized. So anytime if an employer
Right.
says that they want you to pay, I would say probably just run away from that employer, and it is not legal. And there is recourse, DOL and USCIS. There is a lot of recourse that you have in terms of the protection offered from the government, where you have an avenue to kind of bring these kind of issues out. So I think from an industry perspective, because if everybody follows the rules, things will be easier. Because we have elections in about 2 weeks. We're going to have a new president,
Yes.
whether it is a Democratic president or whether it is Republican president. So we know whenever we have a new president, rules will change. The reason is we always, I mean, no system is perfect. So every president wants to improve things and wants to make things better. So we're definitely going to see
Definitely.
rule changes. And if everybody is following the rules, it is very easy to justify the program and why it is so valuable to the industry. And if the new president sees there are violations, I mean, again, they're going to like start thinking that everything is wrong and like completely jeopardize the whole industry. So I think people should, I think, be careful, know the legal options that are available, so everybody follows the rules. Because
Absolutely.
majority of the employers always follow the rules. It is very few people that have a problem. And in politics, what happens is that small issues are always like highlighted, and they make it sound like the entire H-1B program is bad. So that is
Mhm.
the most important thing, because H-1B program contributes to US economy. It is highly useful for US, because everybody who's on H-1B, they are highly specialized and highly educated employees. They are bringing a lot to US economy, to the US technological superiority. So H-1B program, I mean, nobody wants to jeopardize the H-1B program. So it's in everybody's interest to work within the framework and ensure that everybody benefits. People are working, are benefiting, US is benefiting, the society is benefiting.
So true, so true. And I think not always ignorance is bliss. It's always important to know best and do your research properly and abide by every rule, because that's only when we will all be successful and stay out of any kind of trouble. So thank you so much, Chance, for being with us today and giving us such an insightful webinar we had today. And this is the second episode on this. We spoke about, is your H-1B at risk? And we touched upon wage violations, LCA problems, and fees in these two episodes. It was a real good time to have you. Such an honor and a pleasure always. Thank you so much, Chand, for joining us today.
Thank you, Nipasa. Thank you very much.
And I hope to see you again in the coming weeks with another very interesting topic. And friends out there, you please stay with us. And if you resonated with our episode today and our shows with attorney Chand Parvathaneni, please don't forget to like, share, and subscribe to our channel, and also hit the bell icon so that whenever we have discussions like these, you are notified and you can join us immediately. So thank you, Chand, once again, and you have a great day ahead.
You too. Thank you.
Folks out there, you can contact Attorney Chand Parvathaneni, and his details are on the screen. You can call him on his number 817-523-8247, and even email him law@spblawfirm.com, and definitely go visit www.spblawfirm.com to get to know more about Attorney Chand Parvathaneni. And once again, thank you, folks, on YouTube, LinkedIn, and Facebook. Thank you for your questions, and keep commenting, even if you have questions after this live session has ended. We are here to reach out to you with answers and maybe be able to give you directions on how to go about it. So, thank you so much. And this is Nipasa Pradhan saying bye for now. You all out there have a great day ahead, and keep on. Stay tuned to Immigration and Jobs Talk Show.